Good morning, everyone. Welcome to today's webinar. Really appreciate you joining us this morning. We will go ahead and get started. So today we're focusing on the top 10 ways businesses can stay out of court and updates to the Fair Chance Ordinance in San Diego County. Live Well San Diego is celebrating 15 years of promoting health, safety, and well-being. And as part of this milestone, we are hosting a year-long series of webinars, networking events, and online engagement. We are here to stay connected, share new insights, and continue the important work we started together. So my name is Ramona Prado-Lyon, and I manage the business sector with the County of San Diego's Live Well San Diego support team at the Department of Strategy and Community Engagement. I'm honored to be your moderator today. Here's what we have on the agenda. Jennifer Shaw with Shaw Law Group will be presenting on the top ways businesses of all sizes, including small businesses, can stay out of court and establish thriving workplaces. Next, we will hear from Mikey Knabb with the County of San Diego's Office of Labor Standards and Enforcement to learn more about the Fair Chance Ordinance and the penalties that would be in effect on July 1st. After both speakers, we will have a Q&A session. We will also have an opportunity for feedback following the Q&A session. So let's get started. A few reminders before we begin. This webinar is being recorded and your lines are muted. But please remember to submit your questions in the chat box. And if you have any questions, you can use the hand raise function at the bottom of your screen in the reactions tool. If due to time constraints, we don't get to your questions today, or you want to reach out to our team, you can follow up with us via email at the email address listed on the screen and shared in the chat. We will also be sending out answers to questions in a follow-up email. If you would like to receive the recording of today's webinar, please sign up for email updates by scanning the QR code or clicking on the link shared in the chat. We will also be uploading the recording to our Virtual Connection Hub page, so you can check it out there. Now for our first presentation, the top 10 ways small businesses can stay out of court with Jennifer Shaw. Jennifer Shaw is a nationally recognized expert in employment law and the founder of Shaw Law Group. With several decades of experience, she is the go-to advisor for employers navigating complex workplace challenges. From wage hour compliance and anti-discrimination policies to leave laws and hiring best practices, Jennifer provides practical, real-world guidance to help organizations stay ahead. Known for making employment law engaging and accessible, Jennifer has trained thousands of executives, managers, and employees through dynamic interactive sessions like this one today. Using real-world case studies and storytelling, she ensures legal concepts resonate. She also provides one-on-one coaching for senior leaders. Beyond training and advising, Jennifer is a recognized thought leader in the field. A regular contributor to the Daily Recorder, she is often quoted in national publications and appears on radio and television as a workplace expert. Her weekly podcast, Workplace Wake Up, is a must-listen for employers looking to stay informed. She is also deeply committed to pro bono legal work and ensures the firm's attorneys receive billable credit for such matters. If you have any questions for Jennifer, please put them in the chat and we will address them after the presentation. With that, I'll pass it to Jen. Thank you. Take it away.
Oh, thank you so much, Ramona. It is my honor and privilege to be with all of you here today. I know how busy you all are, so I know it's hard to carve time out of your schedule for these kinds of sessions. So I'm so happy that you are able to do it. I promise it will be well worth your time and energy for today. So we are going to focus on my best practices, things that I think you can do based on my 30 plus years of experience advising employers, both big and small, on how to stay out of the courthouse, which is something that I think we should all be striving for. As you know, litigation costs a lot of money. It is very disruptive and it can have a lot of negative repercussions for your positive workplace culture. So as the slide you see on your screen right now says, this program is intended to be an overview. I don't want you to feel like you're getting any specific legal advice about a particular issue. Having said that, you are welcome to ask any questions you would like. We will handle them during the Q&A session, or of course, you're also welcome to raise your hand during the session, and I will be happy to make sure that we get those answered for you. The thing that I want you to think about here today is really making sure that you feel like you are understanding what's going on, you have a focus, You can ask questions about things that might be bugging you. I really want you to take advantage of this opportunity. Also, of course, before you make any changes to your practices, you should consult with your regular employment law counsel. If you don't have regular counsel, that's okay too, because you can always partner with OLSE. They can give you advice. There's lots of different ways to get the help that you may need. Okay, so let's go ahead and jump right in. When we talk about how to stay out of court, and we can go to the next slide. Thank you so much. There are 10 things that I want you to think about. Now, let's be honest. There are probably 100 things you could do to stay out of court. But what I've tried to do is put these in a format for you that will make sense and that will allow you to look at your own internal practices and figure out where there may be some opportunity areas. Okay. So first thing I want you to think about is your hiring practices. And this is something obviously that Mikey will talk about in a little while with respect to the Fair Chance Act, which is really important law and something that's going to have a lot more teeth come July 1. So we really want you to understand what those requirements and obligations are. So Mikey's going to cover that in just a little while. I want to talk generally about hiring practices because here's the truth. If you hire someone or you fire someone, those are the two most risky things you do as an employer. Okay, no doubt about it, no question. So when you think about it from that perspective, how you hire people, how you recruit people is critical. Now, the first thing I want you to understand is you need somebody in your organization who owns the process. What you see on the slide right now is the term human resources. I put that in quotation marks. You may not have an HR person, that's fine. You may be the business owner, the operations manager. There are a lot of different folks who may wear the HR hat in a particular organization, but somebody needs to own the process. And what I mean by that is you've got to make sure you're giving the right paperwork, you're following the right processes, you really understand what your responsibilities and obligations are. So find somebody in the organization who can own that process, okay? Now, as part of this, of course, interviewing is very important. I find I've talked to several employers lately who say, I don't know, I can't really tell what's going on in an interview. Anyway, I just hire people sight unseen and see how they do. That's a huge risk. I don't want you to do that. You at least want to see the person, okay? And even if you're doing an online interview, please make sure that you can see that they are a human, okay? There's all sorts of scams going on out there where people will get jobs with 6 or 7 or 20 different employers. They do just enough online work to make it seem like they may be productive. And in the meantime, there's no way they're doing their work and they're getting checks from, like I said, up to 20 different employers. So you want to see people, okay? You want to ask probing questions. I know that it feels a little bit, I don't know, aggressive almost to be asking questions like, well, why did you leave your prior job? And what kind of an evaluation did you get in that position? Oh, you left Acme Company. Do you think they would welcome you back? Right? There are questions you should be asking. They should be probing. Now, the other thing I want you to think about, though, is it's not just questions about their former employment or their skills or their abilities. You want to ask them questions based on your job description. What are you expecting this person to be able to do? What do you need them to be able to deliver? Okay, so you want to focus those more specific questions on the job description. Now, that of course means you have to have a job description, right? You've got to have something that you can show to your candidates to explain this is what this job is going to all be about, right? So it doesn't have to be fancy and there's all sorts of samples out there, but you need to have a write-up, something in writing that shows, okay, what are our expectations for this job, right? What is going on out there that we need to make sure that everybody can see and understand, okay? Now, the other thing you have to think about is avoiding unlawful inquiries, okay? There are things you're not allowed to ask about. For example, one of the things that you're gonna see is when Mikey starts talking is you got to be careful about criminal conviction inquiries and histories, right? Has somebody had a conviction for some sort of a crime? You know, how do you handle something if you figure out somebody's been arrested? You're not allowed to consider arrest records, but what do you do, right? When you talk about unlawful inquiries, you shouldn't be asking about anything that is based on what we call a protected category. So things like race and color and sex and national origin and marital status, disability, religious belief, color, sexual orientation, pregnancy, military status, any of those things you do not want to be asking about. And the Civil Rights Department has a nice document on their website that is actually called Unlawful Inquiries. And you can find that at, I'll put this in the chat right now, www.crd.ca.gov. And let's see here, crd.ca.gov. And I'm going to tell you to look for the pamphlet. I should have had a link for you, but I didn't. Sorry about that. Okay, on unlawful employment inquiries. Okay, so what I want you to do here is I just want you to understand what you're not supposed to be asking about. All right, now here's the interesting thing, okay? You want to get to know this person. So it is tempting to say, do you go to church? Do you have any children? Are you married? What's your favorite vacation spot? I once had somebody ask me, if I were a tree, what kind of tree would I be? I don't know how insightful that was. I did say a redwood tree because those are my favorite. But you know, ask whatever silly questions you want to ask, but don't go into that realm of protected categories. When I say on this bullet, partner with HR, what I mean is if you have any accommodation issues, for example, if a candidate says they need to have some special testing opportunity, or they can only participate in an online interview, whatever kinds of things may come up, you need to have somebody that you can discuss those issues with, and you can make sure that you understand what your obligations are. So again, anytime we use the term human resources in this program, what I'm talking about is really human resources, the person or the people in your organization who are going to handle workplace issues, hiring, separation, job performance, leaves of absence, reasonable accommodation, wage hour compliance, all of those things. Don't make promises in the interview. So somebody says, I'd like to make $25 an hour. Oh, don't worry, I'm sure we can get that for you. Well, that makes it sound like you're telling them they're going to get $25 an hour. And when you give them an offer letter that is for $20 an hour, they're going to wonder what's going on. All right. Oh, I really want to make sure I can work at home. Oh, yeah, I'm sure after some time we can work that out for you. Maybe, maybe not. Right. Don't make those promises. Here's the thing I do too much. I say everything I can think of about our work environment, where they would work, what they would be doing, and I don't give them a chance to say much of anything. So at the end of the interview, I don't know anything about the candidate. All I know are the things I told the candidate about a firm where I already work. How helpful is that, right? So I've had to train myself. Listen to what the candidate is saying. Ask open-ended questions. By the way, a fabulous first question is, so tell me why you want to work here. Think about that. If they're like, oh, wait, where am I again? Then they're not somebody you're interested in. Not because they don't know who you are, but because they haven't made any effort, right? How committed are they really when they're participating in this interview and they don't even know who they're interviewing with? So I love that first question. So tell me why you want to work here, or what intrigues you about this position, or why do you like this? Oh, Mikey, you're the best. Mikey just put these resources from the CRD up online. Thank you, thank you, thank you. Okay, so hiring practices are critical, all right? Okay, we can go to the next slide. The second thing I want you to think about is how you train your employees. Now, you all know here in California, you have mandatory equal employment opportunity training. You have mandatory workplace violence prevention training. You may have mandatory training when you hire minors. Okay, so you have to provide training, though, that is engaging to them. Now, best of all worlds is you have training live. I would love to be in San Diego right now with you guys, sitting in a conference room, going over these issues, being able to look at you, being able to engage with you a little bit more. I love that. It's not feasible all the time, right? So when you can't do a live training, you do a webinar training. The worst training is the kind that is dead on the internet, where you just are at your own pace going through things. Studies have shown that people retain about 3% of the information that is conveyed in that manner. And I can attest to this. I got a ticket recently, I'm ashamed to admit. I was going a little too quick on the freeway, and I had to go to traffic school. And so I figured, well, I was going to do online traffic school. I'm too busy to go drive 20 minutes and go to traffic school. So I go to do the online training, and I just found myself skipping through the text, going to the quiz questions. If I missed one, I would just guess again until I got it right. I got to the end of this supposed 4-hour training, which took me, I don't know, an hour and 10 minutes, and I couldn't remember one thing. Okay. So because I'm multitasking, I'm going quickly, I'm looking at emails, I'm answering the phone. The more you can do a live training, even if it's over the internet, even if it's a Teams training or a GoToWebinar training, at least you're having an opportunity for live interaction. So make sure that you can do what is possible to get them engaged. Remember that the goal of the training is to tell employees what you expect and then tell them that you're going to hold them accountable. Of course, the third part of that is you must hold them accountable, right? So if they go to a training where you say, my expectation is that you don't engage in any unprofessional or disrespectful conduct at work, then they do it and you don't take any action, well, that training isn't going to mean anything, right? Because they're not going to believe anything you say you're going to do. So you've got to be able to hold people accountable. One of the mistakes we see small businesses make, and other businesses, honestly, but mostly small businesses, because they're overwhelmed, right? You all are trying to get your business online. You're trying to make sure everything's happening. You've got a million different things in the balls in the air, and you don't have a lot of people to delegate things to. What you tend to do is only provide training on the absolute necessary things that you need to train on, right? What is legally required? What do they need to know to succeed in our business? The problem with that is those are the hard skills. The soft skills are also really important. Teaching people how to communicate, how to show empathy, how to train, how to hold people accountable, how to speak up when they have an issue. Those are the softer skills that you want to focus on. And when you do that, when you focus on those softer skills, you will stay out of court because you will have people, who understand what your expectations are and understand how to communicate what is important to them and who really understand what is available to them in the workplace. So that becomes very important too, making sure that you are focusing not only on those technical skills, but also on the emotional intelligence side of things. Also, as I've talked about, training is not going to be helpful if employees are not paying attention. So make sure the trainings are as interactive as possible. Make sure you have good scenarios, good written materials, etc. Okay, so this compliance training is the required training. And then I want you to, as you can, get to that next level of training where you're actually training people to give them skills that will make them want to still stay with you, right? Because you're providing them such benefits and such opportunities.
Jen, would you
Okay,
mind if I add a little bit to what you just said?
absolutely not. Mikey, jump in
So-
anytime.
I appreciate that, Jen. So essentially, I just want to echo one thing that Jen's indicating here, which is that some of the soft skill training that you will engage in is actually training employees on how you prefer to communicate with them and showing them a level of respect for their acumen and their professionalism by setting up your training systems such that they understand why things are the way they are and what's expected and why each of them will be held accountable so that they can know their colleagues are going to be delivering in the same way they will and everyone's rowing in the same direction. It also creates a culture of communication that will also help keep you out of court. Because if they feel comfortable and respected when they can bring an issue to you and that is modeled through the training process, you've created a functional, high-powered team dynamic. So I'll just leave it there, Jen.
Such good feedback. I love it. Totally agree. Okay, let's go ahead and go to the next slide. Let's talk about wage hour laws. Okay, I love wage hour law, and I know a lot of people don't. All right, this is overtime, rest breaks, meal periods, whether somebody's an employee or a contractor, how somebody can be exempt, right? What it means for someone to be exempt. All of these issues are very important. Here's the problem with wage hour. This is the way I think of it. You know how people can be a good cook? Like they go in the kitchen, right? They open the fridge and they say, oh, okay, there's some tomatoes, there's a little basil, there's some garlic, I'll make a pasta, right? And they're not following a recipe, they're just sort of putting it together. Those cooks, in my mind, are very impressive because I'm not that creative when it comes to the kitchen. So I love it when I find people who just open the fridge and they can just whip it out. Those are amazing cooks. Here's the deal. You cannot do that if you are baking. Okay, I love baking. So when I bake a pie or cookies or a cake, I measure things impeccably. That is not what you do when you are cooking, okay? Most of the time when you're cooking, if you're one of those amazing people who can open that fridge and get it done, measuring how many tomatoes you put in the pan or how much olive oil, you're just doing a little this, a little that. When you're doing baking, you got to be precise. Otherwise, the cake falls in the center, right? The frosting does not taste like whipped buttercream, right? You have brownies that don't have that really nice crunch on the top and the soft, gooey center. All right. Wage hour is baking. Okay, wage hour is precision. You've got to know how to pay overtime, how you keep track of people's hours worked, how to not allow them to work off the clock, right? How to make sure they're taking their rest breaks and meal periods. These are what I call the easy hits, right? And I want you to avoid the easy hits. You've got to know how to do this. And here's the interesting thing about wage hour. It's not necessarily intuitive, okay? So, you know, when you're talking about equal employment opportunity, right? You want to prevent harassment in the workplace. It's pretty intuitive that people shouldn't be touching people inappropriately at work, right? If somebody says, well, wouldn't it be okay if I touched my coworker? No, it's not going to be unless you know it's welcome, and then it has to be G-rated, right? So maybe you can give a hug in the workplace, but you got to be careful about how you're doing it. When you talk about wage hour, it's not always logical. So, for example, rest breaks and meal periods. If you ask the average person on the street, they would tell you, well, if you don't want to take a rest break or a meal period, don't do it. That's fine. You're a grown-up. You don't want to take a rest break or meal period. I get it. You don't have to. Oh, but you do in California if you're a non-exempt employee, right? If you're paid for every hour you work, you're not paid a fixed salary that doesn't change based on the quantity or the quality of the hours you work, then you are non-exempt, right? Remember, those folks who are paid that salary are exempt. And that means they're exempt from overtime, rest breaks, meal periods, on-call time, record keeping, all of that. If you're not exempt, then you are not exempt from those rules, all right? So, by the way, these are the things you see under the avoiding the easy hits. These are about 80% of what I see in lawsuits, okay? And claims that are filed under the Private Attorneys General Act, the PAGA Act here in California, which has cost employers millions and millions and millions of dollars, all right? So how do you figure out what you're doing? I want you to conduct a wage hour audit. I want you to look at what you're doing. Does your pay stub have the right information on it? By the way, one of the requirements, Labor Code Section 212, says you better have the exact name of your organization on that pay stub, that tear off portion of the check. So if your company's name is JBL Enterprises, doing business as the Mad Hatter, right? Then you better put that whole thing on the wage statement. That is required by Labor Code Section 212. So for you to do an audit, you got to know what you're looking for. So we do a ton of audits for employers because we sit down and say, okay, here's a checklist. There are lots of different ways you can get this information, but you need to be looking at what you're doing. Ideally, if you do it with a lawyer, it's going to be privileged, which means nobody can take your deposition about that audit process down the road. You did it with a lawyer, or the results of the audit, but you don't have to. You're not required to use an attorney. So figure out, how am I going to double check what's going on here? And you know what the truth is? You're going to know many of your non-compliance areas right away, because you will have been told that people are not taking their rest breaks or meal periods, or that people are clocking out after 8 hours because they know you don't want to pay overtime, but then they keep working. Many times you're going to know these things are happening, and your instinct is going to be to say, well, that's okay, because if they want to do it, that's their choice. No, not the way California law works. Okay. You've got to regularly update your handbooks and your policies. People ask me all the time, how often should I update my California employee handbook? Every January, every year. I guarantee you that every year there will be some change made by the legislature that requires you to update your handbook. And in 33 years, I haven't been wrong. Okay, every year there's something. So just plan on doing it the very beginning of January, rolling that thing out. All right. Remember that not all policies are going to go in your handbook. Many of them will, but some of them you may decide don't need to be available for everybody. That's fine. You can do individual policies for certain things. But it's very, very important that you have updated policies and procedures. One of the ways to beat a PAGA claim, which Mikey, because he's brilliant, just put a link in the chat about the Private Attorney General's Act. And it's so great. This kind of information is just worth its weight in gold, you guys. When you are trying to avoid a claim under PAGA, you've got to have policies that are legally compliant. One of the ways the lawyers will get you is by saying, oh, well, your overtime policy said you only paid weekly overtime, for example, instead of daily overtime. So therefore, everybody who works here was impacted by that negative policy. By the way, it doesn't even matter if you actually did it that way. Okay? So you're not going to be off the hook just because you say, oh yeah, I know that was in my policy, but I didn't do that. And obviously you're going to partner with human resources. Again, I put that in quotes. If you've got questions about what's going on, how to get things done, what the laws or rules may be, you've got a lot of resources out there. Okay, we can go to the next one, please. All right, performance evaluations. I actually just read a really interesting article where this consultant was saying, I tell my employers, my clients, not to do evaluations anymore because I think they're worthless. And I called the person and I said, what? I'm so curious. You wrote this article. You're very well respected. Why do you think it's worthless? And he said, well, because of the halo effect. What's the halo effect? We paint everybody with a broad, nice brush, right? We don't want to have conflict. So we decide, okay, maybe Jen is late. She has a bad attitude. Her work has a lot of errors in it. She's not nice to people. But hey, she's an employee. We don't want to hurt her feelings. So we're going to give her a good evaluation. So many things wrong with that, right? The problem I see with not doing evaluations is you don't have a historical context for how an employee has done. And sometimes you need that to keep yourself out of court. You need that to be able to say to a lawyer who challenges a termination decision, for example, hey, yes, I did terminate this person and I've got performance evaluations and write-ups and all sorts of things to justify why I took the steps that I took. Remember, if you create documentation at the time of a lawsuit or a legal claim, it's there. It's not like you can't use it, but it's not very persuasive because it will be clear that you prepared that after you make the decision to let the person go. So it's very important that you have some documentation and you can show what it is you're doing. So a couple of pointers that you'll see on the screen right now. First off, You got to be on time. You want your employees to be on time. If you tell them they're going to get an annual evaluation on or around their anniversary date, get it on their anniversary date unless it's a holiday or a weekend, and then do it the first business day after. All right. You got to be specific. You don't say things like Jen is lazy. You say Jen missed 4 deadlines out of her last 6. Jen did not proofread her report that she submitted on May 3rd, right? Be specific. If you're not specific, you're not going to get the results you want. Remember, evaluations are not intended to create a documentation trail to get rid of someone. You're trying to save the employee. You're trying to make sure that they can get what they need to succeed. So this is a good opportunity for you to do some check-ins, right? It's got to be fair. Now, listen, I know different supervisors and managers have different expectations. They have different standards. They have different needs. I get it. Okay, no problem. Everybody's not going to get the same evaluations. When I was a school teacher years ago, I was a hard grader. I started with a 0 in the book. And then as you did what you were supposed to do, you got points added, and then you ended up getting the grade you were going to get. I worked with other teachers who started at 100 and subtracted for things that the employee missed, or excuse me, that the student missed. That didn't work for me because I don't want to tell you you're starting at 100. I think it's more motivational saying you're starting with 0. Now, it could be that people react better to I'm starting at 100 and then I'm getting deductions. For me as a teacher, I taught little kids. It just didn't really seem to work. But you got to be fair. You got to be specific. You got to do this on time. Use as many objective criterion as you can, okay? So you're evaluating the performance. Again, not Jen is lazy, but what did Jen do to get you to that conclusion, right? Don't hide the ball. Okay, the report is due tomorrow. I wonder if they're going to do it. Let's see. I'm not going to check on them. I'm not going to offer help. Now, if you would normally offer help, offer help. Okay, as we talked about, no halo effect. You don't paint everybody with a broad brush just because, let's say, somebody else got a good evaluation, or because you just don't want to lose people. You feel like a breathing body in the door is better than nothing, all right? During evaluations, you should not ever discuss leaves of absence or accommodation requests or internal complaints, either made by the employee or against the employee. Now, you may discuss a complaint resolution when you're looking at some sort of disciplinary action, right? So maybe there's some corrective action that's going to remain on the books for a bit beyond the scope of this evaluation. Then it would be relevant to talk about that. But even then, discipline should not be a surprise. Everybody should know exactly what's going on and how you got where you are. Think about this as being a team effort between you, the manager, the supervisor, the superintendent, the leader, the employee. Everybody's got to be involved in this process. You don't want it to just be about what one manager had to say. When you litigate these cases, when you end up in court, okay, which we are trying to avoid by all measures, all right? But if you end up there, you're going to have to defend all the documentation you've created. So you want to have a process for doing this. It's not something haphazard that you should slap together, okay? Okay, we can go to the next slide. Using your resources. Okay, I've talked a lot about this. I'm not going to spend much time in this slide, but I included it because I want you to remember it. You're going to have both internal and external resources. You want to use them consistently. You want to remember who has institutional knowledge and subject matter expertise in your organization, and you want them to be removed from what I call a hot situation, right? You want them to be removed from any involvement in a problematic issue that you're looking into. So using your resources, critical. All right, we can go to the next one. The next one is talk the talk and walk the walk. Okay, you guys, in my opinion, this is absolutely critical. You must lead by example. You must understand that your conduct matters. You must understand that the tone at the top is all that really matters. What messaging is everybody else getting from those folks at the top of the pyramid? All right. I want you to think about mutual respect. Remember, the golden rule is treating other people the way you want to be treated. Doesn't work in the workplace. right? I want you focusing on how they want to be treated at this very high level of respect and professionalism. We call that mutual respect. Okay, so you might be okay with a hug, but you don't know if anybody else is. Okay, the higher up you are in the organization, the more you need to lead by example, the more you need to think about the impact of your behavior. Okay, because as a leader, you take on a little bit of a larger than life persona, and people are really paying attention to what you do, how you do it, what you say, how you say it. All matters. Okay. You've got to do the right thing, even when it's difficult, even when you think, I don't know, this is such a hardship to do this. If you don't do the hard things, how can you expect your employees to do the hard things? Okay. Just won't work. I want you to remember that nothing is off the record. When somebody comes to you and says, hey, I want to tell you something, but you have to promise to keep it confidential. Hey, I'll be discreet about it, but remember what we talked about in our training. I can't keep things absolutely confidential if I'm under an obligation to reveal them, right? So why don't we sit down, tell me what's going on, and we'll take it from there. You can't have any favoritism. Okay, you're going to build a team. Now listen, between you and me, are there going to be some people you like more than others? Yes, there are. Okay, absolutely. But that doesn't mean you favor them. You've got to build a team that can work together even when you're not there. When you call in sick, your team should be humming along. All right. So you've got to talk the talk and walk the walk. I think a lot of people want to be leaders. They want to be managers and supervisors. Sorry, just knocked over the heating thing here. Because they want that power dynamic. They want to have that impact on the workplace, but they're not willing to accept the responsibility. They're not willing to take a step back and say, okay, well, what do I have to be able to do as a leader, as a supervisor or manager? Okay, so you've got to talk the talk and walk the walk. Okay, next slide. When we talk about fairness, I think people get a little bit confused. And so I want to go through this a little bit with you. When we talk about fairness in the workplace, the way to avoid a legal claim, for example, for discrimination, differential treatment based on a protected category, you have to compare what we call similarly situated employees. So if you're comparing how the CEO is being paid with how the accounts receivable clerk is being paid, you know there's going to be a significant difference. That doesn't mean it's an unfair difference, right? Just the fact that something is different doesn't make it unfair. But you're going to have the burden as the employer to show what you're doing is fair, is appropriate, was the right thing to do, right? So I want you to treat your least favorite employee as your favorite, just the same way you would treat your favorite employees. If you're going to make a favor or you're going to give an exception to a policy, which is often perfectly appropriate, let's say you usually don't let people work remotely, but somebody's asked for an accommodation and you've got the documentation and you think it's appropriate to let them do that, then you're going to have to let them do that, right? That's going to be differential treatment that is required by the law, right? So, but you may have to explain, hey, everybody, just want to let you know, Jen's working at home. She's dealing with a challenging issue. Can't go into the details, but you might want to drop her a line and check in with her. Okay. One of the most important things when we're talking about fairness is not rushing to judgment. And this can be really hard because we're human beings. Many of us have been around the block several times, and we start to see a situation and we think, uh-oh, I know what's coming. So I want to prophylactically deal with it. I want to get in front of it. Don't rush to judgment in this area. You may think that it's clear that somebody didn't do their work because of what somebody's told you or what you've observed. But until you dig down and figure it out, you don't really have an answer to the situation. You might feel like you have a little bit of an answer because you got the ball rolling, but you're not going to get that far. So how do you stay out of court? You make employees understand and recognize that you're going to be fair. And that means it may take an extra day or two to get them that investigation report. Okay? just as an example. All right, we can go to the next one. Manage by walking around. Okay. I know I just said this, like this is the most important one, but they're all so important. Management by walking around means you cannot sit in your office or in your cubby with your headphones on, ignoring what's going around. You must physically move around the workplace. You must interact with employees informally and on an unscheduled basis. Now, you are going to have schedules at times. You are going to set up a sort of plan of checking in with folks and making sure that everybody's getting done what they need to be getting done. But the bottom line is you're going to do this in an unscheduled way so that you can really see what's going on. This philosophy, management by walking around, is so huge in so many companies. And it's really provided some amazing benefits, like helping you to evaluate work because you get to see what's happening without somebody putting on sort of their best face for your evaluation meeting. It builds relationships. Employees start trusting you when they see you out there on the floor with them. It opens your lines of communication for the same reason. Like people are willing to have these discussions when they see you walking around. When they see you sitting in your office all day with the door closed, they think you don't have any idea what's going on. Even if you do, and you will have an idea, but you will definitely have more of an idea if you're out there walking around with them. Being empathetic, understanding concerns, really important. I don't care how minor they seem to you. If it's an issue that an employee has raised, we at least want to see if there's a way we can deal with it. The other thing that management by walking around helps you deal with are issues that are detected early by directly observing someone or by recognizing as part of the daily round how something is supposed to be happening and then it isn't, right? That is what we mean by management by walking around, okay?
Hey,
It's
Jen.
really important principle. Yeah, go ahead.
What would your advice be for someone whose employees are almost exclusively remote in terms of managing by walking around?
Yes, you drop into their chat rooms, you drop into their Zooms, you drop into their Teams. Hey, Matilda, it's Jen. Just wanted to check on you. You don't have to make an appointment. I think we've sort of lost that spontaneity because we have folks who are working remote, and we don't remember that they should be on camera. They don't have a right to be off camera with all these filters. Just they can pick whatever background they want, but they should be on camera so you can engage with them. Sure, you're going to set up one-on-ones, Mikey, and have regular meetings. And if they're remote, you might even see if you could get everybody together once a month for a lunch, for example, or a happy hour. But the bottom line is you've got to manage those remote people the same way you do the people who are sitting in front of you. Pop in, give them calls, give them messages, ask them how it's going. Really show that you're dedicated and you understand what it is they're supposed to be doing. That you're not guessing, you're not just letting them do whatever they want because you're guessing. You're actually creating an environment where people understand what is expected of them. So I love that you asked that question because I think a lot of times people think, oh, if I send them home, then my potential liability is lessened and I'm going to have all this free time on my hands. No, you're not. It's hard to manage people who are remote. Does that make sense?
Yeah, that was great. I appreciate it.
Okay. And by the way, if anybody has other questions, just bring them on. This is great. Okay, let's go to the next slide. This one is about the platinum rule. So I mentioned earlier the golden rule, treating other people the way you want to be treated. But that means we may overlook differences in communication styles or learning methods or motivations. The platinum rule requires that we treat others as they want to be treated. This really breaks down barriers. It fosters a sense of belonging and inclusion. It also creates a space in which all voices are heard, valued, and empowered so that everybody can contribute their unique talents, okay? This rule is really important, and we hear about the golden rule all the time, but I'm telling you, if you were raised the way I was raised, where things I'm just not that sensitive. People talked about the craziest things at the dinner table. totally fine. Nobody was upset. If I assume everybody's going to be that way at work, I'm taking a huge risk because chances are that that is not going to be the way they're going to look at the situation. Okay, so follow that platinum rule. Okay, last but not least, we want to talk about the next slide. We want to look at this idea of how do we stay on top of workplace law developments. Okay, this is tough, you guys. The labor and employment law, remember, labor is about unions. Okay, so labor law and then employment law is about harassment, discrimination, retaliation, wage hour, background checks, criminal histories, as Mikey's going to talk about. All of those sort of laws, whether they're labor laws or employment laws, are always in flux. And there are always going to be changes coming down the pike that you may not have known about. So you got to find a way to stay on top of things. We were talking before the webinar kicked off about how easy it is to become overwhelmed as a smaller employer or as a new leader, because you just think, how am I ever going to stay on top of this? And for some of you, you have operations outside of the state. So you've got to look at what is that other state doing, and then how are you going to make sure it's consistent for everybody at a higher level? You've got to be really careful with this. So find 3 resources. Okay, 2 of them are right here, right? OLSE and the county's Live Well program. I mean, these are fabulous resources. Find a law firm you love, follow their blog, follow their podcast, make sure that you know they're giving you solid advice. And then you're not in a situation where you're thinking, okay, wait a minute, what am I really supposed to do here, right? Because you have strategized. So if you know what your resources are, you can stay on top, which will help you ensure compliance and stay out of court. It'll help you assess risks. If you happen to get a demand letter from somebody, that doesn't mean you did anything wrong, okay? And it will also help you determine if policy or handbook changes are needed or necessary. So when we think about this, you guys, and we think about how you can stay on top of things, it's easy to get overwhelmed. It's easy to think, oh, there's 42 blogs I should look at today. Find 2 blogs you love and then follow those, okay? Because you've got amazing resources in both of your organizations here, in the OLSE team and also in the county team. There's just so much here that you can get, all right? Now, the other thing that will help you do is assess your risks. How far do you want to go? What do you actually want to do? And then to determine if there's policy or handbook changes that are needed. We do a legal update every year. We've done them for 25 years. Next year's 26th year. We do them in December and January to try to help everybody stay on top of things. That's what you want to find. You want to find someone with whom you're comfortable and you can trust the information to allow you to get this information in your noggin. We give written materials so people can understand what we're doing. It really makes sense to try to organize as much as you can so that when these resources come on site or are available to do things, they're really understand what their focus is and they understand how to get things done. All right. Okay, I have finished my 45 minutes, I believe. Yes, I have. I want to make sure that, oh, you're so funny. I want to make sure that you guys have the ability to ask questions. So remember, when Mikey's done, we're going to have a little Q&A. And we'll be able to walk you through anything you want to work through, okay? All right, I think, Mikey, it's time for me to turn it over to you. Oh, we're going to do test our knowledge first. Yay. Okay, that's right. I have test our knowledge. I love this. All right, I promise I'll go fast because I don't want to take Mikey's time. All right, true or false? You should treat all of your employees fairly. And the best way to do that is to treat everyone exactly the same. What do you think? True or false? Send me your answers. Send me your answers, everybody. False. Good. You don't treat everybody the same. You treat similarly situated people the same. All right? True or false? Employee training should be informative and engaging to yield the best results. Give me your answers. Just shoot them over on that chat, that Q&A. Yes, true, right? I love Christina. She says, true. That's right. They've got to be engaging. They've got to be informative. True or false? The platinum rule is treating others as you want to be treated. What do you think? That's right, Ramona. False. Awesome, Olive. False. That's right. That's the golden rule. The golden rule is going to get you in trouble, y'all. Don't do that, right? Figure out how people want to be treated consistent with a high level of respect and professionalism. Okay, let's go to the next slide. Managing by walking around helps with all of the following, except A, staying on top of workplace developments, B, building relationships with employees, C, opening lines of communications, and D, understanding concerns. All but what? Give me your answer. A, that's right. You can't stay on top of workplace developments that way, but you can do the other three things, and they're amazing. Number 5, true or false? Employers should avoid conducting wage hour audits because they may inadvertently find something that could result in liability. What do you think? Give me your answer, true or false? What do you think? Should we avoid conducting wage hour audits because they may inadvertently find something that could result in liability? False, false, and false. Listen, you can't go through life like this, right? La, 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 la. You got to know what's happening. Knowledge is power. What you decide to do with that knowledge, of course, is totally up to you, but you want to know what's going on. All right, next slide. You are interviewing candidates for new positions. So far, none of the candidates has impressed you, and your last interview is this afternoon. The candidate's resume looks incredible. During the interview, you start to think that you finally found the perfect employee because she answers all of your questions perfectly. As next steps, you should do all the following, except let the candidate answer questions, promise the candidate that you will meet her salary request, even though it's outside the range you advertised, and avoiding unlawful questions. You should do all of the following except which one? What do you guys think? B, 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 B. That's right. That's right. And oh my gosh, it's so true, Christina. So many people don't do these things the way they're supposed to. That's why this training is so important. All right, let's go to the next one, guys. In summary, look at your 1 through 10 here, folks. I want to make sure that you're following appropriate hiring practices. You're providing engaging compliance and other training. You're following wage hour laws. You're conducting regular performance evals. You're using your resources. You're talking the talk and walking the walk. You're being fair. You're managing by walking around. You're following the platinum rule, and you're staying on top of workplace law developments. You guys, I know this is a lot. I know it's a lot to digest. I know it's a lot to understand. The good news is I think we've answered many questions during this session, so I don't think I've cut Mikey short, at least I hope not. So we can shorten our Q&A a little bit, I think. But everyone, thank you so much for your time and attention. These topics are so important, and it really is truly an honor to partner with OLSE and the county on this program to give you guys this information that is so critical to stay out of the courthouse. Thank you, everybody. I'm going to turn it over to Mikey now.
Thanks, Jen. So anybody who hasn't had the pleasure of learning from Jen before, now you can see that labor standards information can be fun and engaging and exciting. And Jen, I really appreciate that about you. Hopefully I can match the energy. I will try to go quickly because this ordinance and fair chance hiring processes can be a little in the weeds, but I'm going to give you the broad strokes, and then we'll get into any details that are relevant to you during question and answers. So we could go to the next slide. So first, I just want to say the California State Fair Chance Act was passed in 2018. Often these are referred to as ban-the-box laws. So ban-the-box laws have been adopted in many states across the country, but they're not universal. It's not a federal law. The box that we're banning is when you see an application, sometimes there's a little checkbox that next to it will say, check this box if you've ever been convicted of a felony or misdemeanor or any other crime. That box, as you see in this photo on the slide, that's illegal now in the state of California. So if you don't learn anything else from today's training on fair chance hiring practices, The one thing I want you to remember is you are not allowed as an employer to ask about conviction history until after you've made a conditional job offer in any way possible. So don't put it on job postings on Indeed. Don't put it on your applications. Don't ask in the interview. Until you've given someone a conditional job offer, you should not be talking about their conviction history. They're allowed to bring it up on their own. It's their story, it's their life, but you cannot prompt that. We can go to the next slide. The Fair Chance Act requires this as the hiring process. The applicant will give you their resume or application. Following that, you'll do an interview. After the interview, if you like the person and you think they're a good fit for the job, you can make a conditional offer. Now, the word conditional here could be on many conditions. You could have a condition that they are able to get to work on their own accord. They have transportation. You could make it under the condition that they have a certain professional certification. You can make it on the condition that they pass a criminal background check. You don't have to do that. Many employers don't conduct criminal background checks. But if you decide that that's important for your company, then you can do that. So you make the conditional job offer, you do it in writing, and you say, now I'd like to ask your consent to conduct a background check. You can't do it without consent. You're not allowed to just run criminal history reports on anybody on the street. That's a good protection for workers. It's also a good protection for employers who may find themselves in trouble for inappropriate investigations. Once you've gotten the background check back, if it's clean, you can say, okay, you've met our condition, you've got the job, your training starts on X date. But if it's not, and it has a conviction, it shows a conviction, you then have to make an assessment. You have to decide, is this conviction relevant to the work that I'm hiring them to do? So we're going to get into how you make that assessment in a later slide, but this is the point in the process where you make an individualized assessment of the relevance of the conviction history to the job on offer. If you decide that it is relevant, it's too connected. Let's say in this case, you're hiring someone to work at the Gap as a cashier, and they have a conviction for retail theft. You may say, well, listen, we're hiring you to work in retail. We already have a problem with retail theft at our store. We think this is too connected to the role. So we're uncomfortable bringing you onto the team, given that knowledge. So then you give them what's number 6 on this list, a rescission of the job offer. You say, here's what we've seen in your history. This is why we think it's relevant. So unfortunately, we have to rescind our conditional offer. Then you can do a reassessment after you hear back from the applicant. They can say, well, actually, it turns out the criminal history report you've got there says Michael Nab. I'm actually Mikey Nab. That's a different person. So they could say this is an inaccurate report. Or perhaps it's the right person, but the conviction is not accurate. They say, oh, it wasn't actually retail theft. I don't know why that showed up that way. There's a mistake. So they have time to maybe argue the accuracy of the report. They could also, even given that the report is fully accurate, it is Mikey Nab, it is the retail theft that that I was convicted of, but I could say, hey, that was a really long time ago, and since then I've followed all the steps that my parole officer says I have to follow. I've also got a certificate of completion of a certain program at a community college, or I did work while I was incarcerated that is relevant to the job you're hiring for. So they can give you evidence that says, hey, you may want to reconsider. You take that evidence and you do a reassessment. If they want to follow on that part of the process, you do a reassessment, and then you decide. Again, you make an assessment. Well, given all this evidence, I actually do feel more comfortable now, and I feel like I would like to go ahead and let them come work with us. You give them the notification. Your training starts on X date, or you say, unfortunately, given all the retail theft that we've been experiencing, we just had another employee steal from us. I'm not okay with bringing that person on. Then you give them a final notification. In that final notification, you have to tell them where they can file a complaint if they think their rights have been violated under the Fair Chance Act. So we can go to the next slide. So let's just talk about what a conditional job offer means. An example of a permissible question after the conditional job offer, right? So again, never ask these questions until you've already decided that you want to hire someone. The whole point of the Fair Chance Act and the county's Fair Chance Ordinance is to ensure that employers are considering an applicant's experience, their fit for the role, without regard to a mistake they made in their past. The folks who have a conviction history, often it will only reflect the worst decision they've ever made and nothing else. When you get a criminal history report, it doesn't tell you the story of the conviction. It doesn't tell you if someone was the passenger in the getaway car in a bank robbery rather than the person holding the gun. It will just say, you know, aggravated burglary or something. I don't actually know criminal law that well to give a perfect example, but the point is you want to consider this, whether this person's a good fit for your job based on who they are today, not who they were 5 years ago, 7 years ago only. So after you've made the conditional job offer, an example of a permissible question would be, have you ever been convicted of a misdemeanor or felony? And they are allowed to say no, of course, if they've never been convicted, but also if they have and it was sealed or dismissed or expunged or reversed on appeal. So, you know, let's say I've been convicted of retail theft, but then I appeal it, it would show up on my criminal history report. But the reversal would also show up. So if that's the case, the applicant is allowed to say, no, I have not. They can also say no if they withdrew a plea after they completed a court program and they were not convicted of the misdemeanor or felony. So we can go to the next slide. So again, under the Fair Chance Act, there is that same, the steps of process for the hiring. And during your individualized assessment portion where you're deciding, you know, you've seen a conviction, you're deciding, is this relevant to the job I'm offering? The process to follow is nature, time, nature. So the nature of the offense or the conviction and the gravity of that, the amount of time since it happened, right? So like you wouldn't see a conviction from 20 years ago because reports don't go that far back unless you're in certain exempted industries. But if it's been a long time, that might be important to you. You know, people change, they evolve, they grow. And then the nature of the job. So nature of the offense, time since the offense, nature of the job. If someone has been convicted of driving under the influence of alcohol and they're applying to be a cashier at the Gap, that's not relevant. They're not driving for work. They're not working around alcohol. You can't say just because someone broke a law that makes them a dishonest person and therefore you can't hire dishonest people. That's not the way this works. So that's what you should be considering when you fill out these individual assessment forms. We can go to the next slide. Now, if you're an applicant, you're a justice-involved applicant, right? You've had some interaction with the justice system in your past. You've been convicted of a crime of some sort or another. You're applying for you've paid your debt to society, right? You're now looking for work. You apply for a job and you notice, hey, wait a second now. This application has the box on it. And I saw one of Mikey's trainings and I know that that's not legal in the state anymore. Or, you know, there wasn't a box on the application, but in the interview, they asked me about whether I've ever been inside or, you know, they kind of like go around the edges to figure out whether or not I have a criminal history. So employers must do the following when they take back a job offer. They have to notify the candidate in writing. They have to identify the disqualifying conviction. They have to provide a copy of the history report where they learned of the conviction. And they have to then give the candidate 5 business days. So not weekends or holidays. Those don't count in the accrual of the 5. And then they have to tell the applicants that their response can include evidence challenging, as I mentioned, the accuracy of the history report, evidence of rehabilitation, and evidence of circumstances that the applicant believes are important to consider about the nature of their crime and its relevance to the job on offer. We can go to the next slide. Here's this slide. I'm not going to read through all of it, but essentially this is a list of things, examples of things that an applicant could bring back as evidence to say, hey, maybe you should reconsider. And it would be character references, personal accomplishments, the story of the conviction, right? Like I mentioned, the criminal history report is going to be very basic. It's just black and white. But as we know, life is not that way. So you could write a letter on your own behalf if you were an applicant in this type of situation. And then, of course, outlining of the time since the conviction, the length and consistency of your employment history, and evidence of similar work. Now, when we're training justice-involved workers and applicants on these rules, we often mention work while you're incarcerated counts. You should and can put that on your resume or your application, particularly if it's relevant to the role you're applying for. Okay, next slide, please. And I'll try to speed up here. I realize I'm going a little slower than I had thought. So next is reassessment. The employer can consider the information, as I mentioned, the evidence that the applicant brings, and then a final notification. So you're going to notify them in writing. Hey, we got your evidence. We've considered this. Here's our second assessment based on that. And we're going to either rescind the job offer or revoke it, or we're going to bring you in and go ahead and hire you. But in this one, and I know I started this a couple slides ago, you have to tell the candidate their right to file a complaint. You have to tell them where, and that is the Department of Fair Housing and Employment, or if you're in San Diego County, our Office of Labor Standards Enforcement. We can go to the next slide. All right, so the County of San Diego has adopted a Fair Chance Ordinance, which sort of builds additional protections on top of the state's Fair Chance Act. In March of 2024, the Board of Supervisors asked us to draft an ordinance that would do that. And on September 10th of that same year, the board passed the policy, and it went into effect after the 30-day cooling period on October 10th of 2024. Next slide, please. So what the local ordinance does, it is an education enhancement program, and the enforcement starts with education. So if we ever get a complaint, like I mentioned that we just did last week, our first step is to contact the employer and try to remedy the complaint right then and there. We don't go straight to court. We don't go straight to enforcement of or administration of penalties. There's also a streamlined reporting process, which is what I just mentioned. Instead of having to go to the State Department, workers in San Diego County are offered the opportunity to come straight to a local office, which is our Office of Labor Standards Enforcement here at the county. And this is the big important one, okay? So we also now have the authority to issue administrative penalties for violating the ordinance. That is not part of the state act. So this is only applicable in San Diego County, and I'm going to show you which parts of San Diego County because it's actually kind of specific. Again, I mentioned if you only take one thing from today's Fair Chance training, it's not to ask about criminal history until after you've made a conditional job offer. If you're able to take two things, it is don't break this law, because starting on July 1st, there will be a $5,000 penalty for the first violation. And if you make a second violation and the evidence supports that you've violated a worker's rights, it's $10,000. The third one is $20,000. Every time one of these penalties is administered, half of the money collected will go to the impacted applicant. So what that means, again, we do these trainings for workers. You can see my colleague Stephanie in this photo, training a justice-involved worker on their rights under the Fair Chance Act and the Fair Chance Ordinance. We tell them about that. We say, hey, if you report a violation and we can substantiate it, and the employer is found to have broken the law, the penalty will be $5,000 for the first violation, and you will get half of that. So workers are incentivized to let us know when their rights have been violated. So we can go to the next slide. Another change in our ordinance over and above the State Fair Chance Act is that the individualized assessments, when you make those assessments after running the criminal history report, must be in writing, and they have to stay on file for at least 1 year. So when you're hiring someone, you find out that they have justice involvement and it's of concern to you, the individualized assessment, you should do it in writing, and you have to keep it. Well, you have to do it in writing, and you have to keep it on file. Also, once you've given them a job rescission, how do you say that? Rescission? Rescission letter, when you say we want to take back our conditional job offer because of what we learned in your report, you must then give them 5 business days to respond. That's the same as the state law. However, the county now says during that 5-day period, you have to leave that position open. You cannot hire someone else assuming that the evidence that this applicant brings to you will not convince you otherwise. There are emergent circumstances, meaning if there's an emergency or a reason that you can't leave the job open. The example I always use is if it's 4th of July weekend and you're hiring lifeguards, you can't wait to hire lifeguards for this big important tourist day. So that would be an acceptable emergent circumstance. So again, if you're hiring someone, you find out they have justice involvement and you're going through this process, do not fill that position while you're waiting for them to respond with their evidence. Okay, next slide, please. Okay, who's impacted? You see the kind of tan area, which is the unincorporated region of the county. For those who don't know what unincorporated means, it means the parts of the county that are not cities. They're not officially considered cities. The gray areas there, that's the 18 cities within the county, and the tannish areas are the unincorporated areas. If you're a business that operates in those areas and you have 5 or more employees, or if a worker's primary job location is averaging at least 2 hours a week within one of those locations, by the way, that should ring a bell for you if you have remote workers. If they live in those areas, this applies to you. As you can see in that little green box, there are over 14,000 businesses that this would apply to based on those metrics. I would also say if you're in the gray areas, the incorporated cities within San Diego County, you should follow it anyway. It's best practice, and also the State Fair Chance Act applies to all of you. Okay, next slide, please. So these ones I'm gonna like buzz through really fast. Basically, we've created a hiring toolkit that you can access on our website. And I think Ramona has the link to it if you wouldn't mind putting that in the chat, Ramona. These are just essentially like template documents. And if we could go to the next slide, it's going to list out everything that's in the toolkit, and it's on the website that Ramona linked. It's sample language for job openings, like that you can put on Indeed, so that you put this language up there, that means you're compliant with the Fair Chance Act. It does not include any references to criminal history. A conditional job offer, and I apologize, these slides look a little funny because I made them on one program and switched them to another, so hopefully my verbal cues will follow the content well enough. But there's a sample conditional job offer. What we've done in these documents is we've highlighted the parts that you would need to change. And if you don't want to change anything else, that document would be compliant with the law. Now you can personalize them, and you should. But if you just need, hey, these are the basics, this will be compliant with the law, it's all here for you. There's the individualized assessment form, a preliminary job offer revocation letter, an individualized reassessment form, and a final revocation letter. So if we can go to the next slide, you're going to see what each of these kind of looks like. There's the language for a job posting. If we can go to the next slide, here's what the conditional job offer looks like. You'll note there are only 4 little areas that are highlighted that you would need to change: the date, the name of the applicant, the position you're hiring for, and the name of the employer. This is essentially saying, we want to offer you a job, but we have a few conditions we want to make sure that you can meet first. And we can go to the next slide. This is an individualized reassessment form. Very straightforward, simple, and we can go to the next slide. This is the notice of decision to revoke a job offer. This one's 3 pages long. There are a few more highlighted sections, but again, you can use this as a template and just manipulate the highlighted sections, and then you'd be compliant, or you can use this as inspiration to create your own. The important part is that you are letting these folks know why the job has been the offer is being revoked, the nature of the criminal history, the time since that, and the nature of the job, and why they're connected and relevant. The next slide, please. There's the reassessment form. You can go to the next slide. Final revocation notice. They're all similar. We can go to the next slide. And again, these are all available on the OLSE website. If anyone would like to submit a inquiry form or a complaint, this is for workers and employers. If you're wondering, is my hiring practice compliant with the Fair Chance Ordinance? Send us an inquiry. This is what the Board of Supervisors has invested in the Office of Labor Standards Enforcement to have full-time employees here to answer your questions about labor standards, not just under the Fair Chance Ordinance, but also literally anything. How do I ensure that I'm following the law as an employer to keep myself out of expensive trouble and to ensure that I have a thriving workplace? So that's available on our website, as you can see there. Next slide, please. And this is contact information directly for myself and my colleague Stephanie, who's actually on this call. Stephanie works mostly with workers and the broad community to talk about labor standards. And my focus is mainly with employers, business owners, and operators. So the shorthand that we often refer to is Stephanie will talk about your rights and I will talk about your responsibilities. So and there's our direct contact for both of us. And we could go to the next slide. And now we're at Q&A. So thank you for staying with me through the long process, but I hope that it's been helpful.
Mikey, I thought it was fantastic, and it is so important that you've got that toolkit that complies with your specific regulation and ordinance too, which is just fantastic. You guys, as always, hit it out of the park.
Thank you, Jen. I appreciate that. It means a lot from you.
Well, you and Steph are doing a fabulous job. All of you are.
Thank you so much, Jen and Mikey, for both of those presentations. I was telling, my team over here too, this is great information for managers and supervisors, not just for business owners, but I think if you have any kind of responsibility to oversee any staff, everything that you guys talked about is just super important and good to know. So now is our time for questions and answers. But we haven't seen anything in the chat, but I do want to open it up to everybody that's here. If you would like to unmute or raise your hand, please feel free to. We do have a few minutes before we close out. And if there are no questions, please stay on. We would like to get your insight on the material presented today. So I'll pause here.
I actually have a question.
Yeah.
Hi, my name is Christiana, Jennifer, and Mikey. I've been shouting you all out in the chat. I'm so excited that you all are doing this, and I hope you all do many more because I wear several hats in the community. One, my organization does grant writing and grant management. And so we oftentimes are working with nonprofits, universities, startups. I mean, we run the gamut with the type of organization and industry. Is very agnostic. And what we see commonly happening is, especially with startups and small nonprofits who are just starting to kind of get their feet under on solid foundation, is that they will work with volunteers and interns, oftentimes like inching towards employment type of engagement, but thinking that they're safe in that they are a startup or a nonprofit. Or we will see that they are working with someone and they're referencing paying them in equity, sweat equity, but don't have the right paperwork or documentation. And so they're leaving themselves liable for a variety of things. My question is, do you all, one, offer anything that's specific to early stage nonprofits or startups who are in those early stages and don't really have the knowledge, but also the budget to be able to do things the right way, or think they don't have the budget to structure their organization the right way? And then my follow-up question is, do you all ever come out to do trainings in the community with organizations like accelerators and incubators, which we work with as well, to actually do these trainings? And I'll go back on mute. Thank you.
Mikey, I'll let you respond first, and then I will.
Sure. Thanks, Jen. So also Christiana, so good to see you. Jen, I know you're not from San Diego, but Christiana is a big deal here. So it's nice to see you, Christiana.
You were too
Um,
kind, Mikey.
I would say yes, we offer all of those things. The coolest thing that I get to say when folks ask me how I like my job is that I genuinely love my job, because there are only a few OLSEs, Offices of Labor Standards and Enforcement, across the country that have a position like mine, where the office has decided it's worth the investment to have someone on staff who will do everything that you just asked about, Christiana. We will come to the employers, we will customize our training, we will do any question and answer, open, broad question and answer about labor standards to fit the organization or the company's needs, with business owners, operators, managers, and supervisors. So the answer is yes to all those questions. So if you are working with any of those nascent nonprofits or other companies, and they would like some sort of prevention over cure trainings, like to set up systems ahead of time so that they're not having to like backtrack and fix all of the things they were unknowingly doing wrong when they started, that's the best time to bring the education in. So please keep my contact information and send them to me anytime. And then I'll pass it to Jen for the volunteer and intern part, and sweat equity part. These are all very interesting parts of the law, and I prefer to let the real professional attorneys answer that part. But yes, over to you, Jen.
Oh, thank you, Mikey. Yeah, I mean, quite honestly, there's no better resource than what OLSE is offering in this area. It's fantastic. And, you know, I'm just so proud of the program. It's only 4 years old and they've done such an amazing job. In terms of interns and volunteers, you do have to be careful, and you have to be sure that you are holding them accountable to the same general standards, things like equal employment opportunity. Wage hour is important. For example, you can only have a volunteer if you're a nonprofit. So you can't have a volunteer per se, unless you're a nonprofit. You can have an intern, but only if they're getting school credit. So you want to make sure that they are getting school credit. Otherwise, the presumption is they're an employee who must be paid at least minimum wage for all hours worked. Okay, so that's important. I think it's so great to think about where organizations are in their development and in their stages, because when you think about the things that have to be done for a startup, as opposed to some organization that's been around for 5 years, as opposed to someone who's been around for 15 or 20 or 30 years, the needs are different. And so the flexibility is important. So sometimes what that means is you can't have an off-the-shelf product, but you need somebody to just come and provide some more specific information. And OLSE can absolutely do that. I mean, that's the beautiful thing, is that they can come in at any point of an organization. And I know LiveWell's got the same kind of resources. So you are really set in San Diego. I love it. I mean, obviously, if you ever needed an actual lawyer, I'm happy to help you, and I do a lot of pro bono work, but I don't like you to have to call your lawyer unless it's a last resort. I mean, it's so much better to be able to use your community resources.
Yeah, thanks, Jen. And I'll add to Christiana that there are other organizations in San Diego that are specifically built to help startups, like for nonprofits and for-profit industries, so that way that they have the base that they need to like accommodate for all these rules and regulations that are happening when you're building up a business, because you don't know what you don't know. So there are other organizations locally that can support. I'll connect with you through Mikey offline and connect to some of those other resources, just in case you're not aware of some. But if you are, then make sure the work gets done. Awesome. Cool. Well, let's see. We do have a couple minutes that I want to bring up some feedback for everybody that's joined our call today. We would love to know kind of what you thought about this presentation and the work that was presented to you today. We have a short 2-question feedback form. And one is just, today's presentation was relevant to my business. And then of the information presented, what was most valuable to you and your business? Please know that there are no wrong answers, and we'll give you 1 to 2 minutes to fill this out. Thank you. Great. Thank you, everyone, for providing your feedback. Really appreciate it. So I just want to say again, thank you for joining us, and thank you, Jen and Mikey, for both of your presentations and your time this morning. We really appreciate it. Very informative. For any upcoming events that we have for advancing throughout the year, we do have a networking event in August. So for more information and to register, you can visit our Virtual Connection Hub website using the link in the chat. Once again, this page will be updated throughout the year with more details for upcoming events, as well as today's recording. If we missed your question today, or if you have any questions following this, please email us. We can always connect you to Jen and Mikey. As always, you can stay up to date with our webinars and resources like this one today by subscribing to our newsletter as well. The link is in the chat. Everything is in the chat. Yay! Easy access. So thanks. Thank you for our time together today. We really appreciate you, and we hope to connect with you all soon. Thank you.
Thank you all so much, Ramona. Great